Pardon?
Yes, I guess I'll represent myself.
That you understand that if you can't afford to hire an attorney, one would be appointed for you.
I don't know what he would do for me.
Mr. Walker, you've been arrested for violating your probation with community corrections because it appears from the date that you were sentenced, you may have never reported to them. You have a $10,000 cash or surety bond. Do you want the court to consider appointing an attorney for you?
Okay.
I don't know. They never noted on any of these docket sheets who your attorney was.
I don't have an attorney, ma'am.
He's never had one, Judge.
Huh?
He's never had one.
He entered a plea to a possession of methamphetamine, level 5 drug felony without an attorney. Is that what you're telling me?
Yep.
Well, do you want an attorney now?
Well, I don't know. I don't know why I need one. I'm charged with probation violation.
Yes.
Is today a show cause?
No, it's to advise you of why you're here,
Oh, okay.
your bond is, give you a court date, an evidentiary hearing date, which is July 26th at 2:30.
Okay. Yeah, I don't know. I don't necessarily need an attorney.
Okay. All right. You have a
Okay.
bond. Go ahead and fill out a waiver of counsel, if you will, and put it in the. We'll file it. File.
Yeah. Right. I'm not going to sign anything though. I'm not going to sign anything.
Well,
Yeah.
I don't think the court can do anything with you if you don't waive counsel or have somebody appointed, one or the other.
I don't.
When is the last time that you worked?
About a year ago, maybe a little over a year ago.
All right. How old are you?
Whenever, how old am I? I'm 60. Whenever they first brought me in here, that's the last time I worked. Whenever you all started arresting me for driving on a suspended.
Okay. Well, I'm
a little over a year ago.
Okay, so I'm going to go ahead and appoint Jim Watts as standby counsel. If you don't want him, you don't have to use him, but he'll be available for you, okay?
Yes, ma'am. I'll take counsel, no doubt.
All right. Thank you, sir.
Okay, thank you.
All right, let's go with Albert Hicks. Albert Hicks. How he got on my docket, I don't know. This is the city of Detroit versus Albert Hemmer Hicks Jr. Appearance for the record, please.
Elwood S. Berry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks, and no one is to speak on my behalf. I'm my own attorney.
You're your own attorney. You're an attorney registered by the state of Michigan.
You don't practice to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything.
Okay, you have been practicing law across the bench since we started this, and I'm challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date, or you want the offer in the back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right. Well,
I'm
Trial date,
challenging jurisdiction.
trial date, I'm denying, what is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so,
Honor your oath of office, please. Honor your oath of office, okay?
are we going to sit here and debate those
It's not a
positions?
debate. It's my constitutional right. It's my constitutional right.
You think so?
I
Okay,
know
so,
so. Are you violating my constitutional rights on how you deem them to be?
no, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a
Please.
transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you gonna do today, Mr. Hicks?
Challenge jurisdiction
And how are you challenging that?
because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am, in this case,
Okay.
and I deny that motion.
Why you
If
deny
that
the
even-
motion? Because you don't
Even
have.
even
You don't
even if
have.
that is, that's so Mr. Hicks. You're a grown man. Let's have a few seconds. Wait a minute. Let's have a few second conversation, okay? Now
Okay.
let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay? So take your hood off, please. So, other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this.
Part 1, midnight to 11 o'clock. Here, we witness the tension from the start. The defendants are brought to court, and the judge reads the charges, explaining the basics of arraignment and rights. Already, one defendant challenges the court, claiming sovereign status and refusing counsel. The clash between personal beliefs and legal procedures sets the stage for the chaos to come.
What basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two
As a
options.
matter of fact, hold on, give me a minute. You
Go
even
ahead.
went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one, wait a minute, you were the one, Mr. Hicks, that said, oh, you can say all that while you're on the bench. That's what the court rules are. You gotta follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything. That's all public
Oh,
information.
you're acting tough now? You're acting tough now? Behind the bench?
Mr. Hicks.
Mr.
Let's not go there, all right? Did
Do you
you
have the
say that
transcript?
last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes,
yeah,
I did.
I thought about
You
that.
don't even have a
I
license
thought
to
about that. Listen, this whole.
have license to practice law. Come on, the jig is up. The jig is up.
All right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now I'm going to give you two options. The first option is you can either take the deal that's in the file,
I'm
or
not.
we can. Oh, okay. Don't talk
Then
while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got
Don't
your
talk
paperwork ready. I got your paperwork ready. You really
Don't
want to
talk.
You
There
really
you go
want to
again.
this?
All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court, okay? All right. So the other option is we set a jury trial. And we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So, do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you. Everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have a right to either or. You're not the one.
No, you don't have a right to. No, you don't have a right to either or.
Yes, I do. Of course, I do.
All right. I'm moving on.
All right, move on.
You didn't answer my question, so I'm moving on. And I'm gonna put you out, or at least mute yourself. All right, let's do this, and let's go back on the record one more time with Mr. Hicks.
For the record, Your Honor, Diachiku Mason, City of Detroit, 43471. This is the date and time set for a final pretrial in this matter. Your Honor, I did subpoena my officers to be here today for the final pretrial, and I do not see them here today.
Remove your hat, please. No drinking, please. Treat this like you're in the courthouse. Remove your hat, please, Mr. Hicks. All right. What are we gonna do? The officers were supposed to be here today. I'm only dealing with SP 144-2547, counts 1, 2, and 3, SP 144-27651, and SP 500-872-1. I'm only dealing with those matters. And the officers are not here. We're gonna make this easy. And now, what I don't appreciate is, I thought about that comment that you made that last time. Basically, you're almost like a little lightweight threat that you had toward me, saying that, oh, I'm only doing this. I'm only this way because I'm being protected by the bench. That's absolutely not. I'm the same way 24 hours a day. Okay? So let's get that straight. This robe has nothing to do with me as a man. All right, I'm gonna dismiss the cases because no officer here.
I would like to collect my costs and fees.
Pardon me?
I would like to collect my costs and fees for having to defend myself.
I don't want to hear anything else you have to say.
Oh, beautiful.
All right, bye.
Is that Elder Hicks?
Yes.
Okay, and how do you know that person?
He was my partner, and he is the father of my children.
Okay. How long were you guys partners for?
14 years.
My honor. So, for the record, I've made this special visitation under duress pertaining to the matters of Jonathan Troy, Faifo Leaso Maliatoa Schuster. For I am beneficiary, I am sovereign, I am man, the flesh lives, the blood flows. I am a non-U.S. citizen, American national. I am sui juris imperfecta sana. I reserve all rights. I do not understand the status, and so I ask you ma'am. What is your name? What is your nationality, and what is your status?
I'm Judge Grant. I am a citizen, and I'm the judge in this court. You are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply, not having proper registration on the vehicle, expired over 2 months, and then there was also a driving violation. Wheels were off the roadway. Last two are infractions. So,
ma'am, jurisdiction cannot be proven unless status is established. You have not established status, and so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case with prejudice.
That would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I've challenged the jurisdiction, and jurisdiction must be proven.
Not happen today.
Jurisdiction must be proven.
To hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that violated my rights, who are also going to be getting sued.
This is not personal to me, that these situations happen. I was a presiding judge of the family court for 8 years. These are conversations I have with my colleagues on a daily basis.
The first defendant aggressively disputes the court's jurisdiction, claiming he's a non-U.S. citizen American national. He refuses legal representation and objects to the judge entering a plea for him. The judge carefully explains that a not guilty plea is standard and that jurisdiction must be proven. This sets up the ongoing battle between his claims and courtroom authority.
When citizens file UCC statements against us, against our property, we have to have lawyers in our court represent us to remove these filings against us.
And the business, we call this foreshadowing.
It would just add to that, and I don't think that you need to go that route.
While I review this incident report. Okay, so this is authored by Brandon Carlsrud, signed under penalty of perjury. All right, I do find probable cause with the charges. I will be entering not guilty pleas.
Ma'am, you cannot practice law from the bench. I object.
Noted.
You cannot enter a plea for somebody. That is, practicing bench from the law.
Unless you want to enter a plea of guilty, today there'll be a plea of not guilty. I understand you are objecting.
Ma'am, I object. I challenge the jurisdiction. Jurisdiction has not been proven. Status has not been proven or established. And once again, you haven't even established, your nationality or your status. I am a non-U.S. citizen American national by way of American Samoa. I reserve all my rights.
Is this something that we need to consider a competency evaluation for?
You may need to consider ordering ability to proceed, but...
You question my competency because I'm establishing status and asking you to prove jurisdiction is outrageous. And so, again, if jurisdiction cannot be proven, I move to dismiss this with prejudice based on the grounds that you cannot prove jurisdiction.
Right, I've reviewed this. You were driving in the city of Lake Forest Park. You were violating
Again,
laws.
I was not driving. Again, I have rights.
You were behind
and my rights were violated. My rights were violated. My right to travel freely unencumbered was violated. There was no emergency in which the officer needed to put on his red and blue lights. And so, again, if status cannot be set, jurisdiction cannot be proven, I move to dismiss this matter with prejudice.
That's denied. So you've made your record. Right now, I'm going to directly appoint counsel from the bench. Ms. McDonald.
Again, I am
you.
sui juris in propria persona. I stand on my 2 feet. I'm in my proper person. And so I reserve all my rights.
I understand that, and I've acknowledged that. I'm not dismissing your case today. I'm going to hear from Ms. McDonald as to the city's position on release.
Yes, Your Honor. I am going to be asking that the bail remain the same. It looks like it's currently set at $2,000. I do have some concern regarding his willingness and ability to reappear if he was released on his own recognizance, as well as concerned about community safety and risk of reoffending, given his temperament in the court today.
Your Honor, Mr. Schuster would ask the court to release him on his own recognizance. These are not violent offenses. I don't see that he has any convictions for violent offenses. There was an assault from 2021 that was dismissed. He may have a view of the law that is different than the city's, but that in itself does not indicate that he won't come to court or that he would in any way try to subvert court proceedings. So we'd ask the court to release him on standard conditions.
Well, the court can consider whether or not Mr. Schuster is likely to reappear for future court hearings. What I hear from him today is that he completely objects to this court having any jurisdiction. I don't have a good faith basis that Mr. Schuster will return if I were to release him. I do see that he has a prior conviction for DUI. He's on a deferred prosecution at this time in Seattle Municipal Court. He's not complying with conditions if he's driving without a license and driving without a required ignition interlock device. Also, indication that Mr. Schuster will not abide the court's orders to appear on his promise. I want to look at the Seattle Municipal case and see when he's next scheduled to appear.
Like you had mentioned too, in 2021, same situation, or not same situation, a situation occurred in which they tried to charge me. They didn't have jurisdiction. It was dismissed. And again, I don't want any charges against me because I do have the deferral, which would obviously violate that deferral. And so I will make any visitations, special visitations to the court to handle any matters pertaining to Jonathan Troy Faifale, also Malietoa Schuster. I'm a man, I'm free, and I want it to stay that way.
I do see it looks like he's got at least 3 prior warrants. He has 2 priors out of Benton County, 1 out of Lower Kittitas. The previous warrants history.
And throughout this process of going to courts, I've had to learn a lot. And so I know it's no game to just not show and make visitations. That's not what I want to do. And again, jurisdiction does need to be proven, whether it's today or another date. And if you want to violate my rights even further by not releasing me on my own recognizance, ma'am, Jennifer Grant, then like I had mentioned earlier, you, along with the officer and sergeants who are already going to be getting sued, I mean, there's no need to add you as well, especially when you know the law.
I don't see another date set until February 12th of 2025 in
Seattle Municipal Court.
Yeah.
Well, Mr. Schuster, I have to do what I believe is appropriate in this case, and that is to set bail, and any threats to sue me or to take any action against me, I can't be swayed by that. So
it's not a threat. It's just what it is. Because my rights have been violated, and if my rights are going to be furthermore violated.
$2,000. I do not believe that you will respond to the court's order to come back. I do base that upon the conduct in this case, as well as the prior FTA history. So bail will be $2,000. If you're able to post bail, you are to return for your next court date. You are to have no criminal law violations. You're not to drive unless you have a valid license and insurance. And
when are you setting that court date, Miss?
Required by the Department of Licensing. You will be represented because I'm going to assign counsel.
I am sui juris in propria persona. I present myself. I don't need to be represented by anybody. I stand on my own 2 feet.
These are criminal charges that have significant consequences for you, so it's in your best interest to have counsel.
Again, I stand on my own 2 feet. I do not need to be represented by anybody. I present myself, sui juris in propria persona.
If you want to be your own counsel, you'll have to go through a full colloquy and waive all your rights to have representation. It's your constitutional right.
I do not accept being represented by anybody. Again, I present myself. I am beneficiary. I am sovereign.
The defendant refuses counsel, arguing he can represent himself. The judge evaluates bail, considering past failures to appear, community safety, and risk of flight. Despite his insistence on self-representation, the judge imposes $2,000 bail and strict conditions. The tension escalates as he continues asserting sovereign citizen beliefs, challenging the limits of legal procedure.
National, a non-U.S. citizen American national by way of America Samoa, like I had mentioned earlier. I reserve my rights, and I do not need to be represented by anybody.
All right. The time for trial expiration is 8/9/24.
Again, if you are practicing law from the bench and putting a plea in for me, I object to that. You cannot practice law from the bench.
Next court date will be on June 24th. That's 2 weeks out.
So for the record, you have not established status, you have not proven jurisdiction, and you're denying my rights. Is that correct?
I don't know what you think would establish my status, but I do have status to sit in this court.
You are a U.S. citizen. A U.S. citizen cannot sit a bench. You're asking me to sign something that you pleaded for me. Is that correct?
I'm giving you notice of the conditions that I have set, as well as bail.
You said yes, you pleaded for me?
Probable cause. If you are able to post that bail and get out of custody, those are my expectations that you will come back on that court date and that you will abide by the conditions that I have imposed. Those are being ordered today. So that is what's happening today. And we are giving you that notice. You can refuse to sign that notice, and we'll note that you were provided a copy in writing and that you refused to sign.
I do not understand.
Which part of it do you not understand that you have a
I do not understand how you can practice law from the bench.
I am the judge and I am setting the conditions.
Well, you also entered a plea for me, correct?
What we're doing at arraignment is the plea is being entered. You're not pleading guilty, so on your behalf, I'm entering a not guilty plea.
So, correct, you are pleading for me, correct?
There are 2 pleas.
And if you plead for me, you're practicing law from the bench. You cannot practice law from the bench, so I object.
I'm going to give you that piece of paper and we're done with your hearing today. We will see you in 2 weeks. Okay?
Jennifer Grant, you will be taken further.
And then we've got Mr. Martin.
He claims to be an attorney, so here we speak with Mr. Fanlo.
I'm looking forward to it. All right, this is 2-4.
The judge formally enters a not guilty plea on behalf of the defendant. He objects, claiming the judge is practicing law from the bench. The judge clarifies this is standard practice to protect defendants who refuse to plead. Written notice of bail, conditions, and expectations is provided. The conflict between personal beliefs and procedural rules remains palpable.
8-8, the state of Michigan versus Eric Joseph Martin. Sir, can you tell me your name?
Oh, not the Roman Sesticate Trust, if that's what you're wondering.
Okay. Are you going to tell me your name or not, Mr. Martin?
I just want to make it clear, I'm not the legal fiction corporate entity defendant.
Okay. All right.
If I give
Sir, if you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please let the court know immediately. You are here today on count 1, domestic violence. There's an allegation that on June 8th of 2024 in the city of Taylor at 9074 Clifford, that you did make an assault or an assault and battery upon Crystal Nicole Martin, a resident or former resident of your household, contrary to MCL 750.81 parent 2. This is a misdemeanor punishable by up to 93 days in jail and or $500. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Those are the charges against you. You've been brought to court on a misdemeanor charge, and you have the following basic rights: to plead guilty, not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered, and you may plead no contest with the permission of the court. You have the right to a trial by a jury and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, meaning you cannot afford to pay for an attorney. If the offense requires a minimum jail sentence, this charge does not have a minimum jail sentence. The court determines that it might sentence you to jail, and the appointing authority, which is the court, would decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of the appointed attorney, and you may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must then determine your ability to pay. Mr. Fanto, a court-appointed defense attorney, is present in the courtroom. It's my understanding he attempted to meet with you, and he was advised that you did not want to speak with him. Is that correct?
Because of the unfairness of the laws that would fraudulently assume if I take a lawyer that I would be giving up my right to be one of the sovereign people and be fraudulently assumed to be a legal fiction defendant. Yes, I have refused as a lawyer.
Mr. Martin, if you have a trial, you have the following rights: to call witnesses to speak for you at trial, and you could get an order signed by the court to require those witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecuting official could not comment on your refusal to testify. You also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind, and you will give up the rights that I just listed to you. You also have the right to be released on bond. If you are now on probation or parole and you enter a plea of guilty, or a finding of guilt is made by a judge or a jury, it may result in a violation of your probation or parole. The court can sentence you to jail and fines plus cost, and the court must tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, and both, which I've already done. Fines, costs, and other financial obligations imposed by the court must be paid at the time of assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, you can contact the court immediately and request a payment alternative. So those are your constitutional rights going forward, Mr. Martin.
I want to make it clear I have been illegally arrested here by Barbara Wade, okay, because he just went by her lies saying I kicked her. As soon as he walked through my door, I'm the one that called 911 on Kristen Martin, okay?
All right, sir, you have a constitutional right to remain silent, and anything you say with respect to this case could potentially be used against you in a court of law. So I would advise you at this time to remain silent with respect to the actual facts or allegations listed in the complaint and misdemeanor complaint, which I've read to you. Sir, are you gainfully employed?
Well, I wish to finish, before I answer your questions, I will answer your questions, I'm going to finish exercising my First Amendment right, freedom of speech, and continue what I was saying. Now, again, I was arrested illegally.
You are to appear in court as directed. I'm not going to argue with you, Mr. Martin. I understand your sovereign citizen argument. It's not the first time I've seen it or heard it. You are under the jurisdiction of this court. This court has jurisdiction under the Michigan Constitution and the laws of the state of Michigan. You are charged with a 93-day misdemeanor, sir. You've been advised of all of your rights. Okay, you have a First Amendment right, certainly, but you are here for an arraignment, not to lecture me on sovereign citizen beliefs, okay? I'm trying to get you through this and make sure you understand the process. You are to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crime.
Eric Martin faces misdemeanor domestic violence charges and immediately disputes jurisdiction. He refuses counsel, claims illegal arrest, and insists on his rights as a sovereign citizen. The judge explains his constitutional rights, clarifies no-contact orders, and advises him to remain silent on factual allegations. The courtroom tension grows as Martin attempts to control the narrative.
You're to immediately notify the court of change of address or phone number. You're to have no contact with complainant Crystal Martin in this case. Do you understand me?
Well, I do not understand in that I do not stand under the charges, the false fraudulent charges, but I do comprehend. But as I was saying, I was illegally arrested in violation of my due process rights. There's not sufficient evidence for my arrest that I did any domestic violence. Bardaway just arrested me anyway. There's no video of me assaulting her. She did not see it. She just told a lie. I actually filed a PPO on her.
Sir, do you understand that they have no contact with Crystal Martin?
Then you need to tell her, do not come to my house. She keeps coming to my house so she can set me up with these lies because my sister keeps letting her over. I have no, I don't want to contact her, but she needs to stop coming over to my house. You know, I'm living with her 33 years.
Miss Maudlin,
let me finish talking. I have the first thing right to talk.
Mr. Martin, it's clear to me at this point that you have no respect for the court. I believe that you're a danger. I can't get any information from you as to whether or not you have another place to reside, whether or not you understand the court's no contact provision. I need to know that you understand what I am telling you, because I am attempting to set a bond on your case. And if you want a bond on your case, you've waived your right to an attorney. And I'm trying to figure out, do you have another place to stay? Do you understand what no contact means? And if you're not going to express to me that you have an understanding of what I'm saying, and if we can't get on the same page about that, then I'm inclined to not give you a bond. Do you understand me, Mr. Martin?
I comprehend you, yes.
Okay, do you understand that I said you were to have no contact with Crystal Martin?
Yes, but she needs to stop coming over to my house. I'm not trying to contact her. She's coming over to my house and she can make false allegations like this, setting up so she can have the whole house to herself, her and my sister. This is what the whole agenda is of her with my sister. Lisa Martin tried this before. Even though I proved to the court before the video, my sister Lisa Martin trying to set me up with lies and try swinging at me, assaulting me. I have this on video saying that Crystal Martin here. I have her on video swinging at me and dealing with the prior case she tried to bring me. Okay. So I have the evidence that she's aggressive towards me.
Mr. Martin, does Crystal Martin live at the home on Clifford Street?
Yes, she comes over like for a day or two, and my sister lets her come over, and she stays there for a day or two, yes, and then, here and there.
Okay, so your sister owns the home?
No, she doesn't own the home thing. So my understanding is the bank really owns it. It's always been like my parents' house. But I don't even think really my parents own it because they didn't finish paying off the mortgage or whatever. So I think technically it's the bank's house, but me and my brother and sister have been staying there for a long time. Me there for like 32 years. My parents have passed away now, so now it's like a fight with them two. They're trying to take over the whole house by coming with false allegations, by telling cops, oh, he assaulted me all the time. There's no evidence. not true, it's a lie, it's insufficient evidence, in violation of my due process rights, but Barbara Wade arrested me anyways, and this is just what she wants. So they can have the whole house to themselves. I even filed a case with Crystal Martin.
All right, so you're not to have contact with Crystal Martin. You're not to return to 9074 Clipper in the city of Detroit, or in the city of Taylor, I'm sorry. You're allowed
Objection, in violation of my due process. You cannot deny me my right to live at my house because of an unsupported allegation by her, which is a lie at that. Like I said, the cop had no sufficient evidence. She just told a lie, and the guy didn't even, Barbara Wade did, as a police officer, just came to me and arrested me right off the bat. That violates my due process rights, which is sufficient evidence.
Sir, you're allowed one visit to the premises to obtain personal belongings. You must be accompanied by a police officer.
And I want Barbara Wade. Well, hold on, I'm gonna let you finish. I'm just gonna say what I got to say, so you don't cut me off. And I want Barbara Wade arrested for illegal arrest. I want Barbara Wade arrested for illegally arresting me. I want him charged for assault and battery, for illegally arresting me, and kidnapping.
Okay.
Because it was without my consent.
Mr. Martin, if you are not allowed at the 9074 Clipper Street address, where will you be staying?
I am allowed. I don't have nowhere else to live. That's my house. I'm allowed there. You ordered that illegal. That violates my due process.
All right. He has a $2,000 cash bomb with a GPS tether.
Yes,
and he's not to
return. Personal bond.
He's not to appear at 9.
Innocent without guilty.
He cannot come to 9074 Clipper or be in contact with Crystal Martin.
Martin argues the no contact order restricts his ability to live in his family home. The judge sets clear boundaries. He cannot go to the property or contact the complainant, and bail is set at $2,000 with GPS tether monitoring. Martin continues asserting his personal rights, but the court enforces measures to protect complainants and ensure compliance, demonstrating the practical limits of sovereign citizen claims.
All right, now we're going to move to Habib versus Bouvier. All right, so remember when we last came on this matter, there were some issues that had come up that the court was not quite aware of. I don't think I think it may have been the reports. I had not yet read them. And some of the things that were being said I wasn't familiar with. So I asked everybody to come back so that I can read through those reports and have a better understanding of the backgrounds of everybody. And so I've had a chance to.
Your Honor?
Oh. Okay, give me a. So the court had an opportunity to review those and has a better understanding of the background. I can't remember exactly how far we got in there. I don't know if Ms. Giles even made recommendations at that time. I don't think we got that far, but I'm not sure if you all remember or not. But I have read the recommendations in the report.
I don't think we got that far last time, Your Honor.
Okay, all right. So the let's see. So since I have that background, let me start by calling Ms. Giles. Raise your right hand. Do you solemnly swear or affirm testimony about to give in the case is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and if you would, we have Ms. Bouvier. Ms. Bouvier, you need to turn your video on because we're in the middle of trial. Middle of the hearing now. So you have to have your video on. You turn your mic off, but your video needs to be on.
Your Honor, for the record, before we proceed this matter, there are some facts I must state for the record. I'm here on special restricted appearance as the representative of the descendant. And I do not wish to waive any rights, rather statutorial or procedural. And for the record, as the authorized representative, executor, beneficiary, I have demanded a jury trial in regards to this matter. Moving forward, for the record, Your Honor, I have filed an amended notice of recusal with an affidavit of fact on May 29, 2024. With all due respect, Your Honor, I have not received a response from you in regards to this notice. Please note for the record, I have presented to this court on special restricted delivery all presentments today. Moving forward, according to Georgia Code Section 15-12-122 and 2020 Georgia Code Section 91138, rights to a jury trial is a reserved right. Please note for the record, at this time, I do not wish to add nor subtract anything from my presentments, and I stand behind my documents. And at this time, I respectfully excuse myself from this proceeding to await all notices concerning the trial by jury according to the law.
Okay. So first, you filed a motion for recusal, which the court denied. Looks like you filed, you need to turn your video back on. If you don't turn your video back on, I'm going to have a hearing without you. Okay? So turn your video back on. All right. You filed a motion for recusal, which the court reviewed and denied without there being sufficient evidence. I think you filed an amended one, which the court did not receive a copy of. You were supposed to send that to Chambers if you actually wanted me to respond to it. But you filed it via e-file. I'm noticing it now. It's going to be denied for the very same reasons. With regard to your request for a trial, this is a custody matter. It cannot be a trial by jury because you can't have a trial by jury on a custody matter. So that issue will be denied. As for your representation, the court will consider you London Bouvier. That's who you are. That's what the court consider you as. If you want to consider yourself as anything else, that'll be up to you. But when I make a decision, it's going to be for your government name, London Bouvier. And that's what the law of Georgia is going to hold accountable. So when you don't do what I asked to do, your representative or whoever you think you might be won't be going to jail. It will be you, London Bouvier. Okay? So I want to make sure you understand that. So is that clear to you? All right, we're going to proceed in these proceedings. If you want to participate, that's up to you. If you don't want to participate, that's up to you. But I am going to make a ruling, and the law will be what the law is. I suggest you should participate so that you can be heard, and that the concerns that you have, the court will have an opportunity to hear them. That'll be up to you. Okay? Has this order been followed? Is it being followed?
Your Honor, that's why we're here.
It's not being followed.
No.
No, right. We filed a contempt on this order on May 7th.
Really? I had thought that this matter was coming back on the calendar because I continued it from the last matter. But now I understand. Okay, so there's also the contempt on the interim order. All right. Got it. I got it. All right. Yeah, all other issues shall remain. Okay. All right. So the order isn't being followed.
It is not.
That's the issue. It being followed at all, like no visitation, or just being...
No visitation at all, Judge.
All right. Ms. Bouvier, I've indicated to you once before that your video has to stay on. This will be my last warning to you. Turn your video on. Ms. Bouvier, if I say it again, I'm going to find you in contempt of court. If I say it again, I'm going to find you in contempt. So when any issue happens before, I'm going to have my deputies come get you. Okay? You turn it off again, I will find you in contempt of court. All right? So you will spend 10 days in the DeKalb County Jail. You turn the video off again, okay? Did you understand me, Ms. Bouvier? Did you understand me, Ms. Bouvier? Unmute yourself and say so. Ms. Bouvier, I'm going to ask you one more time. I'm going to excuse you from this hearing. I'm going to find you in contempt, and I will pick you up. And your child will then go to Mr. Habib. Unmute.
I stand behind my documents. For the record, I stand behind my documents.
You can stand behind whatever you want. Do not unmute like I asked you. Ms. Marshall, go ahead and remove Ms. Bouvier from these proceedings.
Yes, ma'am.
I find you in contempt of court. 10 days in the DeKalb County Jail. Child will be presented to Mr. Habib. These matters will be continued thereafter.
Karen Boer disrupts a custody hearing, refusing to follow court instructions and repeatedly turning off her video. The judge patiently warns her, then holds her in contempt when she disobeys, sentencing her to 10 days in jail and awarding temporary custody to the father. The court demonstrates authority, ensuring proceedings continue despite her defiance, highlighting the consequences of ignoring legal orders.